Hi students! In the classes I have already taken, I know you have come across various terms which you are not familiar with like memorandum, articles, memorandum of association of a company, articles of association of a company, company, body corporate, corporation and so on. Now I will go in detail about that. I will make a separate video for explaining such terms that you find unfamiliar here. Actually, studying learning company law, that terms are everything is coming in next chapters. We being discussing in detail. But so far, what we have learned on regard the terms which you are unfamiliar with, I will make a separate video on here itself. Okay, now let's begin our today's topic. We have been discussing about companies and classification of companies, types of companies. Being discussing about the types of companies. We classified companies on the basis of incorporation, on the basis of liability, on the basis of control, and on other criteria. And so far we have discussed in previous session companies or classification of companies on the basis of incorporation and on the basis of liability. What are they? On the companies on the basis of incorporation are chartered company, statutory company, registered company, and on the basis of liability, companies are classified as company limited by shares, company limited by guarantee, and unlimited company. And next classification of company, or the next way in which a company is classified, is classification of companies on the basis of control. On the basis of control, companies are classified as government company, holding and subsidiary company, foreign company, and associate company. That's the topic we are discussing in this video. Let's move on to our topic, companies on the basis of control. What are the companies on the basis of control? On the basis of control, companies are classified as government company, holding and subsidiary company, foreign company, and associate company. Okay, let's begin our topic. Companies on the basis of control. Let's move on to our first head, or the first heading under the session. Under the classification. Company on the basis of control, companies are classified as government company, holding and subsidiary company, foreign company, and associate company. Okay, let's begin describing about each of the head. On the basis of control, companies are classified as government company. What's a government company? The definition of government company is provided in section 245 of Companies Act. Companies Act, which Companies Act we are saying it now? We are talking about Companies Act 2013. What is a government company? A government company is a company wherein not less than 51% of the paid up share capital is held by central government, any state government or governments, partly by central government and partly by one or more state governments. Okay, this is what is meant by a government company. What do you mean by a government company? The definition is clearly provided in section 245 of the Companies Act. For a government company, not less than 51% of the paid up share capital. 51% of the paid up capital, not any share capital less than the 15%, that is held by the central government or by any state government or governments, or any state government or state governments. That means either it is held by central government, other way it is held by any state government. For say Kerala state government, Tamil Nadu state government, that are all state government. Or it can be held by state governments also. That means Kerala state government, Tamil Nadu state government, Karnataka state government, like state governments together can hold also, together can hold even the share capital, not less than 51% of the paid up share capital. Or for a government company, the shares can be held by partly by the central government and partly by one or more state government. In a government company, central government hold 51% or more of the paid up share capital that can be held by central government and state government. By central government and a state government, or by different state government. For example, central government and Kerala state government can hold 51 percentage 51 percentage or more of the paid up share capital of some government company, or together with, I mean here, partly by central government and partly and central government and state governments of Kerala, state government of Kerala, state government of Tamil Nadu, state government of Karnataka can hold 51 percentage of more 51 percentage or more of the paid up share capital of a government company. That's what is meant by a government company. Once more, you recall the topic. A government company is the company in which not less than 51 percentage of the paid up share capital is held by central government, any state government or governments, or partly by central government and partly by one or more state governments. Okay, a subsidiary of a government company is also a government company. A company which already there is an existing government company which fulfills the conditions to what conditions of a government company. Already there is a government company. A government company is existing, and any company which is a subsidiary of that government company, that is also a government company. And these government companies are not at all government departments or government establishments. These government companies are not at all any department of the government or any government establishment. The government company is government company itself. And the employees of the employees, okay, and the employees are not at all the employees of the central or state government. We told in a government company, not less than 51 percentage of the paid up share capital is held by central government or a state government, or state governments, or partly by central government and a state government, or partly by central government and state governments. We have already discussed. Being so, even being so, the employees of a government company are not at all the employees of the respective central or any state governments. And government companies are exactly like any companies which are registered under the Companies Act, and the winding up procedures for a government company is also similar to any other companies which is incorporated under Companies Act. Okay, now we can discuss about holding and subsidiary company. What is a holding company? The definition of holding company is clearly provided in section 246 of the Companies Act. And the definition of the subsidiary company is clearly given in section 287 of Companies Act 2013. Holding company is defined in section 246 of the Companies Act 2013, and subsidiary company is defined in section 287 of the Companies Act 2013. Okay, let's discuss about holding company. What is a holding company? A company which controls another company is a holding company. A company which controls another company is the holding company. And what's a subsidiary company? Subsidiary company is a company in which another company or the other company controls the composition of its board of directors and holds more than half in nominal value of its share capital. And subsidiary of a third company, subsidiary of the controlling company. For a company to be a subsidiary of another company, these are the requisites which are to be fulfilled. For a subsidiary company, there must be another company, that is the holding company. And what are the requirements? The holding company controls the composition of its board of directors. The composition of the board of directors of a subsidiary company is controlled by the holding company and holds more than half in nominal value of its share capital. And the holding company holds a company in which another company holds more than half in nominal value of its share capital, that is a subsidiary company. And a company which is subsidiary of a third company, subsidiary of a third company, being that third company is subsidiary of the controlling company, that is also a subsidiary company. For a company to be a subsidiary of another company, either the composition of board of directors of the said subsidiary company must be controlled by the other company, which is termed as the holding company, or the holding company, or the company which is termed as the holding company holds more than half of the nominal value of its share capital of the subsidiary company, or this subsidiary company is a subsidiary of any company, being that particular company is a subsidiary company of the other company, that is the holding company. In such a case also, the subsidiary company becomes the other company. A company becomes subsidiary of another company. Being discussing here what we have meant by the composition of its board of directors. Composition of board of directors is the power without the consent or concurrence of other persons to appoint or remove majority of the directors. That is the composition of its board of directors. Composition of its board of directors is the composition of the directors, and that includes the power without the consent or concurrence of other person to appoint or remove majority of the directors. And total share capital. What is meant by total share capital? That total share capital includes equity shares and convertible preference shares. And being discussing here, what is meant by control? Control is defined under Section 227 of the Companies Act. What is meant by control? Control is the right to appoint majority of the directors to control the management or policy decisions. Control is the right to appoint the majority of the directors. Control also includes the capacity to control the management or policy decisions. And the capacity to control the management or policy decisions, how that is exercisable. By whom that being got exercised by person or persons, individually or in concern, directly or indirectly. How that is exercisable. How the power to control the management of policy decisions becomes exercisable by virtue of shareholding, management rights, shareholders' agreements, voting agreements, and any other manner. That's what's meant by control. Control is the right to appoint the majority of the directors and also the right to control the management or policy decisions, being that is exercisable by person or persons, individually or in concern, directly or indirectly, by way of shareholding, management rights, shareholders' agreements, voting agreements, or any other manner. Next, we can discuss about foreign company. We have mentioned that everything in the classification of companies on the basis of control. Classification of companies on the basis of control. Foreign company. Section 242 of the Companies Act 2013 clearly defines what is foreign company. A company or a body corporate incorporated outside India, which has place of business in India or conduct any business activity in India, is a foreign company. How a company can have place of business in India? A company can have place of business in India by itself, either by itself or through an agent. That can be by physically or directly or by electronic mode. And that place of business in India also includes a share transfer office or share registration office. Place of business is in India. A foreign company is a company or body corporate incorporated outside India and having place of business in India and conduct any business activity in India. Section 379 to 393 deals with foreign companies. It's a section of Companies Act, Section 379 to 393 is dealing with the foreign companies. Okay, and therein Section 379 is specifying about the application of the Act for foreign companies. Application of what Act? Application of Companies Act 2013 to foreign company. That has been discussed in Section 379 of Companies Act. What's that? Application of Companies Act to foreign companies as per Section 379 of the Companies Act. 50% or more paid up share capital of the foreign company held by Indian citizens or body corporate incorporated in India. For the Companies Act 2013 to be applied on foreign companies, it is said that it is provided that 50% or more of the paid up share capital of that foreign company that must be held by Indian citizens or body corporate incorporated in India. Being that case, Section 379 of Companies Act 2013 came applicable to foreign companies. And also the company has to comply the provisions of complying the provisions of the act, provisions of which act? Companies Act 2013 Provisions Act. The company has to function with regard to the notifications in accordance with the notifications of the central government. And any foreign company which establishes a place of business in India must, within 30 days of the establishment of such a place of business, shall file with ROC. Who is ROC? Register of Companies. File with ROC for registration certain documents. That's another condition. A foreign company which establish a place of business in India. Any foreign company. We have already discussed what is a foreign company. A foreign company is a company or body corporate a foreign company is clearly defined in Section 242 of the Companies Act. A foreign company is a company or body corporate incorporated outside India, having place of business in India, or conduct any business activity in India. Place of business in India itself or through agent, physical or through electronic mode, includes a share transfer office or registration office, and conduct any business activity in India in any other manner. Being such foreign company which establishes a place of business in India must, within 30 days of the establishment of such place of business in India, must file with ROC for registration certain documents. What are the documents to be delivered to ROC? Here, ROC is Register of Companies. Here, the documents to be delivered to ROC by foreign companies. Section 380 of the Companies Act 2013 describes which are the documents which are to be delivered to ROC by the foreign companies. Certified copy of MOA and AOA of company, Memorandum of Association and Article of Association of the company. That certified copy of the Memorandum of Association and Articles of Association are to be filed with the company. If that is not in English translation, the certified copy of the if the Memorandum and Articles of the company are not in English, the certified copy of the English translation of that memorandum or memorandum of association or article of association of the foreign company should be submitted to ROA. The next matter to file with ROC is full address of the registered or principal office of the company. That is to be filed with the ROC, along the list of directors and secretary that must be also filed to the ROC. The next document to be filed by the company is the name and address. The name and address of whom? Person resident in India authorized to accept any notices or other documents required to be served on the company. That must be also be filed with ROC of the company. What are the documents? Certified copy of Memorandum of Association or Articles of Association, Memorandum of Association or Articles of Association of company has to be filed with ROC. If that is not in English, the translation of certified English translation of such Memorandum of Association and Articles of Association must be filed with the company. Then full address of registered or principal office of the company must be filed to ROC. The list of directors and secretary must file to the ROC. Then the names and address of person resident in India and the persons who are authorized to accept any notices or other documents required to be served on the company. That must also be submitted to ROC of companies, along the full address of the principal place of business in India, of the principal places of business in India, that must also be filed to ROC, along the particulars of opening and closing place of business in India, its earlier associations. That particulars have to be particulars have to be filed to ROC. Along the declaration has to be a declaration that none of the directors of the company or authorized representative of the company has ever been convicted or debarred from formation of companies and management in India and abroad. Such declaration must also be filed with ROC, and any other prescribed information that must also be submitted to ROC by the company. These are the documents which are to be submitted by the companies, which are required to be submitted by foreign companies to ROC. And this is done with regard to with section 380 of the Companies Act 2013. Okay, now let's discuss on about the accounts of foreign company. What's accounts of foreign company? Accounts of foreign company. Section 381 of the Companies Act describes about accounts of foreign company. The foreign company has to maintain book of accounts and file a copy of balance sheet and profit and loss account to whom? In prescribed form to ROC at every calendar year, and that must be accompanied by the list of place of business established by foreign company in India. With regard section 381, these are the accounts which are to be submitted by foreign company. This is absolutely different from the documents that are to be delivered to ROC by foreign company. The documents that are to be delivered by ROC, to ROC by foreign companies are described in section 380. That includes certified copy of memorandum of association and articles of the company. If that is not in English, the English translation of the certified copy must be filed. The full address of the registered or principal office of the company that must be provided. The list of directors and secretary names and address. List and directors of secretary names and address of person resident in India, and those who are authorized to accept any notices or other documents required to be served on the company. That must be filed with ROC. The full address of the principal place of business in India that must be provided with ROC, and the particulars of opening and closing place of business in India and the opening and closing of place of business in India on all earlier occasions, that particulars must be submitted to ROC, and the declaration that none of the directors of the company authorized representative in India, none of the directors of the company or authorized representative in India have ever been convicted or debarred from formation of the companies and management in India and abroad. That must be also be submitted to the ROC, and any other prescribed information. That are the documents which are to be provided to the ROC as per section 380 of the Companies Act 2013. And the accounts of the foreign company which are to be filed with ROC are foreign company has to maintain book of accounts and file copy of balance sheet and profit and loss account in prescribed form to ROC at every calendar year, and that must be accompanied by list of place of business established by foreign company in India. And section 382 describes on the display of name of the foreign company. The foreign company has to ensure that the name of the company, the country of incorporation, and the fact of the fact of the liability of the members or limited liability of the members, that must be exhibited in specified places or documents. Okay. Now we can discuss on about activities which are held as not constituting carrying on business. In which circumstance that is coming with regard to our detailed description on foreign companies. Okay, let's move on to what is a foreign company. The earlier definition. What is a foreign company? A foreign company is a company which is incorporated outside India and which has place of business in India itself or through its agent physically or electronic mode, and includes a share transfer office or share registration office, and conduct any business activity in India. A foreign company has place of business in India and conduct any business activity in India in any other manner. Here, what are activities not constituting carrying on business? This conduct any business activity in India. I mean, here, not the point. A foreign company has place of business in India and conduct any business activity in India. And certain activities which are done by companies are not held as constituting carrying on business. What are those activities? That's an important point to be noted. Carrying small transactions, conducting meeting of shareholders or even directors, opening or operating bank accounts, transferring of shares or other securities, operating through independent contractors, procuring orders, creating or financing of debts, charges, etc. on property, securing or collecting debts or enforcing claims to the property of any kind. This everything are the transactions which are done with related to a company. But these activities are not constituted or not accounted for conducting business activity. These transactions are not counted as transactions which included in the definition of foreign company. Conduct any business activity in India. That's a foreign company conducts any business activity in India. But the activities which I have named before, carrying on small transactions, such activities, that is not counted as a business activity being defining on about or being saying about a foreign company. Okay. Then, with regard defining a foreign company, we have mentioned that a foreign company has place of business in India itself or through an agent, physically or electronic mode. What is this electronic mode? Electronic mode means carrying out transactions electronically. What are the electronic transactions? The electronic transactions are the following activities. These activities are carried out electronically, hence they are called electronic mode of carrying on business. The following activities are electronic mode of business transactions. They are business to business, B2B, and business to consumer transactions, data interchange, other digital supply transactions, the offer to accept deposit or accepted deposit or subscription of securities in India or from citizen of India, financial settlements, web-based marketing, advisory and transactional services, database services and products, supply chain management, online services. These all are transactions which can be carrying out electronically, and being these transactions are carried out electronically, that forms the carrying out transactions in electronic mode. And online services, what are the online services? Telemarketing, telecommuting, telemedicine, education and information research. That services, everything can be provided through online, and that is termed as that are some online services. Then data communication services. These services, the services which I have listed now, or these activities can be conducted by email, mobile devices, social media, cloud computing, document management, voice and data transmission. Such activities are termed as can be conducted by these modes, and being they conducted electronically, they are termed as electronic mode of transactions. This can be conducted by these modes: email, mobile devices, social media, cloud computing, document management, voice data transmission, etc. or otherwise. Being that everything constitute what? The electronic mode of conducting on business by a foreign company. I know here you have come across various terms like what is web-based marketing or advisory and transactional services, database services, supply chain management, or cloud computing, email, document management. These are the general terms. I will give a detail. I will give the meaning of this I will give detailed meaning of this heads in a separate video. These are the services, or these are the way the services are provided by foreign companies through electronic mode or otherwise. Okay. The next topic with related to classification of companies on the basis of control is associate company. Section 26 of the Companies Act clearly defines about an associate company. What is an associate company? Associate company is described in relation to another company. Being in relation to another company, a company which the other company has significant influence. Significant influence in what? Significant influence? That is an associate company. Here, what is meant by the significant influence? Significant influence means control, and the control is at least 20% of the total share capital or business decisions under an agreement. What is included in this total share capital? Paid up equity shares and convertible preference shares. And subsidiary company of the company and joint venture company are not included within the meaning of associate company. Okay, what is an associate company? Section 26 of the Companies Act 2013 describes what is an associate company. In relation to another company, a company which other company has significant influence. Significant influence is termed as an associate company. And significant influence means the control on at least 20% of the total share capital and business decisions under agreement. And the total share capital includes paid up share capital and convertible preference shares. And subsidiary company and joint venture company are not at all included within the meaning of associate company. And what is joint venture company? Like maybe you have confusions regarding the various terms I'm discussing. I will make a separate video explaining various terms which have come across on our study on the topic company law. And what's more with regard this associate company? This associate company, why associate companies are formed? The associate companies add more governance and transparency in the working of the company. For they provide a more rational and objective framework for associate relationship between the companies. And related party, and section 276 of the Companies Act says that the related party includes associate company. Section 276 of the Companies Act is describing about what is related party, and that related party includes associate company. And contract with associate company require disclosure, approval, or entry in statutory register, and applicable to contract with a related party. For the contract with the associate company require every disclosure, approval, and entry in statutory register that is applicable to contract with a related party. Here, let us define about what is a related party. We have already said section 276 of the Companies Act defines a related party. What is a related party? This is 276 of the Companies Act. Therein describes a related party with reference to company means